Is it possible that I can question a doctor in a medical malpractice deposition for 2.5 or 3 hours and not get a single objection from his attorney? Is that possible? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, it is possible. In fact, this happened just the other day. I was questioning a doctor in a medical malpractice case, and this was the target doctor, the target defendant. And you should know that the person who brings the lawsuit is known as the plaintiff, and the people who are being sued are known as defendants. And the lawyers who represent those doctors and hospitals, we call them defense attorneys. During the course of the lawsuit, we will have an opportunity to question each other's witnesses. So that typically means that the defense lawyer will have a chance to question the injured patient, the injured client, first, in the process known as a deposition. It's a pretrial question and answer session that's given under oath. And typically during COVID times, it takes place on a Zoom video call. All right. A few weeks or months later, I will then have an opportunity to question the various doctors who were involved in my client's care and treatment. When I question a doctor, there are many times where the defense attorney feels somewhat threatened or they don't like the question that I am asking, in which case they will raise an objection and they will say, "Objection! Mr. Oginski, can you rephrase your question?" Sure, no problem, I'll rephrase it. For whatever reason, the opposing lawyer did not like the way I asked the question. Maybe it was not a great question, maybe I needed to rephrase it to formulate it better or so that it reads better in the transcript when now you're reading it later on. I have no problem rephrasing a question 5 times, 10 times, or doing it so that I get an answer from the doctor. And I'm not looking for a particular answer, but I want the doctor to answer my particular question, or at least a version of it. Now, there are other instances where I will ask the doctor hypothetical questions. You see, in New York, I am permitted to ask the doctor questions as if he or she is a medical expert. And I'm permitted to ask the doctor to assume certain facts to be true. And the purpose of that is so that now I can ask the doctor what his expert medical opinion is if our version of the facts are true. And the doctor is required to then answer those questions. Oftentimes, the defense lawyer will make objections to my questions, my hypothetical opinion questions. Why? Because the attorney knows that those questions are very dangerous. The attorney knows that if, in fact, at trial, the jury believes our version of the facts, and now the doctor has admitted that yes, if certain things were done differently, this patient would not have suffered the following injuries. Now, that's the doctor testifying, assuming the following facts to be true. And if the jury believes our facts, guess what? Now I have the doctor telling the jury in his own words from his pretrial questioning that yes, if you believe our version of the facts, he admits that this should not have happened. Being able to get the doctor to admit certain things in hypothetical opinion questions is a very powerful strategy to showing that we are slightly more likely right than wrong, that what we are claiming is true. So getting back to the title that I raised in this video, is it possible that I can go through a multi-hour deposition questioning the doctor whom you have sued in this lawsuit and not get a single objection from the defense attorney? The answer is yes, it is possible. It doesn't happen all the time, but there are some instances where the opposing attorney is an experienced trial attorney. And they know what questions I am permitted to ask. And they know that even if they raise an objection, they still have to allow the doctor to answer those questions. And that's the rub. You see, many people think that if an attorney makes an objection, that the witness does not have to answer the question during this pretrial deposition process. And that would be incorrect. So whether it's an injured patient who now is in the middle of being questioned, and now I say objection to a particular question, in all likelihood, my client is going to have to answer that question even though I objected to it, and I put that objection on the record. Now, when questioning a doctor, the defense lawyer knows the same exact thing. If there is a question to which they believe is improper and should not be answered, they are going to tell the doctor, "Objection, I direct my client not to answer that question." And then the attorneys will have a legal discussion, a legal argument about whether or not it's really appropriate for the defense lawyer to do that. But putting that aside for a moment, most of the time, in almost every instance I should say, when I ask the doctor a question, even if the attorney makes an objection, the doctor will still have to answer those questions. So I have found in my career that the best attorneys, the smartest attorneys, the more experienced attorneys are the ones who simply allow those questions to be asked, often without making any particular objection. And here's something else that you may not know that a lot of people simply don't talk about. Even if an attorney does not raise an objection during the course of this pretrial deposition, and your case goes all the way to trial, and the same question is asked of the doctor, that lawyer, the defense lawyer, still has every opportunity and every right to jump up out of his seat and yell out, "Objection, Judge! That question is totally improper." And now the judge is going to make a ruling on whether or not he agrees with the defense lawyer or not. The fact that he did not raise an objection during the course of the pretrial deposition to a particular question does not mean that he cannot do it at the time of trial. So I have found that the best attorneys are ones who recognize, yes, these questions are dangerous to their client, but I am still permitted to ask them. Many attorneys, many of these defense lawyers decide, you know what, I'm going to put my objection on the record and then tell the doctor he can still answer the question if he's able to. So why do I share this information with you? I share it with you because this comes up in every single medical malpractice deposition of a doctor. The defense attorney is always faced with whether or not to make an objection, specifically when I ask questions about hypothetical opinion questions. Doctor, I want you to assume that Mrs. Jones came into your office complaining of A, B, and C. Would you agree in that instance good medical care requires that you do X, Y, and Z? Yes or no? And now I'll continue the hypothetical. And ultimately, my goal is to say, doctor, would you agree that if you fail to do X, Y, and Z, that would be a departure from the standard of care? Isn't that true? Yes. And then ultimately, my goal is to ask the doctor, doctor, are you aware of the injuries my client suffered? Well, no, I'm not. Okay. I want you to assume that Mrs. Jones required the following surgical procedures as a result of what occurred during your care and treatment. Assuming that to be true, would you agree that had you done X, Y, and Z at the very beginning, none of these injuries would have occurred? And now that usually prompts the defense attorney to make an objection, say, I object, those facts are not in evidence, or that's not true. I say, that's the whole point. We believe these facts to be true. I understand that you don't, doctor. However, if those facts are true, can we agree that my client's injuries would not have occurred? And now, either the doctor will give me an opinion or will say, no, I don't have an opinion. So why do I share this information with you? I share it with you because I have a few minutes while I'm walking the beach. My wife is busy picking seashells, to open your eyes and to help you understand how these types of cases work in New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.